seated. We are on the record in 18CV27149, Byers versus Dyke. Both Mr. and Ms. Dyke are present. Mr. Tissot is present on behalf of Mr. Byers, and we were originally scheduled to cover a variety of things, but that's all changed in light of the dismissal filed by Mr. Tissot. Mr. and Ms. Dyke, I understand and have seen several documents and reviewed those documents that you filed objecting to or opposing the dismissal. Was there anything else that you wanted to add by way of argument with regard to the notice of dismissal?
Well, we did object. We obviously object to the form of it. Are you talking about simply the dismissal itself?
I want to start with simply the dismissal.
Right.
If the dismissal occurs, might be the better way to look at that. Then we can talk about the form of the judgment of dismissal. I think those, while obviously related, are two separate things.
Right. Well, what we can say in the way of background is it should have came a year ago. We informed our opponent of necessity of possession, and they did nothing to investigate whether or not those claims had merit, as we all know, ad nauseum. And so it would be one thing if that dismissal would have come earlier. Okay, Mr. Tissot, I don't know what opportunity he had to consult with the other counsel. It would have been good for them to consult and say, yeah, let's dismiss it then. He proceeded with a number of Hail Mary efforts to sustain meritless claims. And so it's odious that the dismissal comes at this point after an extreme amount of wasted time.
I certainly can understand your position there, but I'm not hearing a basis that would enable me to deny the dismissal under the rule, which essentially allows a dismissal without an order of the court.
Okay, well, there's a matter of our counterclaim.
Okay.
We were hoping to have time to consult with counsel on that, but we haven't. So we feel a counterclaim is in order, and I filed a motion for leave of court to amend our pleadings so that we could address that.
And this is the claim of blanking on the term defamation. Thank you.
Originally, we felt there was fraudulent conduct. We're able to better articulate that now by virtue of discovery in the way of providing false information to an insurance provider that was defaming to us.
It looked to me from reviewing your motion to amend that you were primarily alleging acts by Mr. Tissot.
Well, there's this unity of interest. So I can't, because of what do they call that?
Attorney-client privilege.
Right. I don't know to what degree Mr. Byers has been involved. So a lot of that is ambiguous, and ultimately we will be filing a lawsuit if need be against him for defamation.
Okay. The other counterclaims that you raised, and I forget in which document that you've recently filed that you identified or raised the counterclaims from your original answer. I did want to address those since you brought that up in one of the oppositions or objections to the dismissal, and I apologize for not having at the tips of my fingers which specific document that was in. I have a couple of issues with those counterclaims. One, ORCP 23 makes it pretty clear that an amended pleading can't refer back to the other. It's got to be self-inclusive.
Does that apply to any filing?
It doesn't apply to any filing. it applies to particular filings, and this would be the amended answer. The other issue that I've got in reviewing the answer, just to make sure that there wasn't some issue there, I went back and looked at that as well. And the counterclaims, one seeks to compel a non-party, Stewart Title, to negotiate. Claim 2 seeks compensation, I think, for both you and Mr. Byers, again, from a non-party, Stewart Title. And then counterclaim 3 was seeking financial compensation from Mr. Tissot and Ms. Thompson, his assistant. And again, they're non-parties, so those wouldn't be valid counterclaims in this case anyway. So I don't see, short of your motion to amend your pleading, that there currently is a counterclaim in the case. Mr. Tissot, did you have anything on the motion to amend their pleadings? I recognize it was just recently filed.
Yeah, no, I think that, it's appropriate to dismiss this case, have this case be over with. If they want to proceed further on, then it would be a different case. So I would object to the amendment.
So I think so that I can get all this in the right order to get us through the process, I do need to address that motion to amend the pleadings. And I'm going to deny that motion for a few reasons, but primarily, go ahead, Mr. Beck.
Can you remind me of the ORCP on?
To amend?
Yes.
23. ORCP 23. And with regard to that motion, the primary reason that I'm going to deny it is because it really looks to me like the claim involves potentially Mr. Byers in as far as Mr. Tissot may have been acting at his direction, but also involves claims against Mr. Tissot, who is not a party to the current case. And so it would be necessary to involve him as a party for that counterclaim to go forward in its entirety. Given the stage we're at in this case, it makes sense that if that claim is going to go forward, that it do so in its own case as opposed to as a counterclaim in this one. Additionally, and this is more a technical issue, the motion doesn't comply with the ORCP, or excuse me, the UTCR that requires when you file an amended pleading that, or when you file a motion to amend a pleading, that a draft of that the proposed amended pleading be attached. And there are some particulars as to what needs to occur there. That wasn't included, but that's certainly not a primary reason that I deny the motion at this point. It's really down to the stage of our litigation here and the fact that the counterclaims appear based on the motion to directly involve a non-party as one of the potential defendants. And we couldn't get complete relief in this case without joining them. In that case, it's probably better off as its separate, unknown case. Mr. Dyke, you had something else?
We would be very happy to file a counterclaim against the plaintiff himself. It says right here in ORCP 23, leave shall be freely given when justice so requires. I think it can be easily proven that false information was given to an insurance provider that was defamatory to us. And I believe that justifies allowing us to amend to address that. It only creates more headache and havoc if we have to file a separate lawsuit against Mr. Byers. It's not really fair to everybody to waste more time dragging this out.
And I think my point is that in order for it to go forward, as you've outlined in your motion, you would need to file a separate case against Mr. Tissot. And I don't see how we benefit by including this claim in this case and pursuing a separate case there.
We're happy to make it against the plaintiff. We can forget our counterclaims and address our request to amend.
I'm not sure I understood what you just said there. You said you're happy to forget your counterclaims. If you forget your counterclaims, what are we amending?
I'm saying we have a counterclaim that we would like to include and by way of amendment.
Okay, I think I understand what you're saying. I'm still going to deny the motion. Again, at this stage of this litigation, the fact that the counterclaim pretty clearly involves folks who are not parties in roles where they would need to be parties in order for this counterclaim to go forward. Certainly, the ruling doesn't prohibit you from filing that claim. I think it's appropriate.
Because of the resistance to discovery, some of this wasn't discovered until I put the dates, like in November. And we didn't really get the documents showing the clear transmission of false information to Stewart Title until November. So some of this is of new heightened concern.
And I understand that based on what you filed in your motion. But again, this ruling does not prohibit you from pursuing that claim. It's merely getting it out of this case, which then gets us to the dismissal, which, based on ORCP 54, I think is appropriate, as I outlined in my letter earlier, which I think then gets us to a form of a judgment. And I know you have both submitted proposed forms. Mr. Tissot, why is your proposed form of judgment the better of the two?
Well, I think that Mr. Duck's proposed judgment is proposing $30,000 in attorney fees.
Objection.
There's no basis.
Objection.
Hang on, Mr. Duck. I'll get to your issues when Mr. Tissot's done.
There's no basis for attorney fees. Number one, because he doesn't have an attorney. So there's no basis for attorney fees because he hasn't. Number two, he hasn't submitted a cost bill supporting any attorney fees to the extent there was a secret attorney involved. So there's no basis for attorney fees of any sort. The prevailing party fees is a kind of another question. Certainly, by way of the dismissal, the defendants are prevailing parties on 2 counts, but then there was the first count in which Mr. Byers was the prevailing party, and I think that was really the heart of the litigation. So
Objection.
I think the court can split prevailing party fees between
Objection.
2 prevailing parties, and I suggest to you that I submit to you that each prevailing party getting half of $325, which is the statutory amount, would offset each other, and in which case there's probably no point in even awarding it. So I think that this seems appropriate. As far as the prevailing party fees, he's also seeking. There is a statute that the statute does allow for the court could, in its discretion, award up to $5,000 in prevailing party fees. There's a list of factors that are set out, and I think the heart of that really has to do with reasonableness of the claim. So the claim that we were pursuing, or the claim that is, of course, the trespass claim, and there's no question that there is a trespass
Objection.
claim. By virtue of the adverse possession being granted, I mean the quiet title being granted, there was a trespass that occurred. There's a question as to the amount of the damages.
Objection.
There's a question as to whether the attorney fees would have been appropriate in that case.
Objection.
Based on the letter. But it was certainly reasonable to bring a claim for trespass.
Objection.
There's no question that there's a trespass that took place. Taking what appeared to be a cue from the court that at the last hearing that the court was skeptical about